AHLA is pleased to present this special series highlighting the top 10 health law issues of 2023, where we bring together thought leaders from across the health law field to discuss the major trends and developments of the year. Support for AHLA in this series is provided by PYA, which helps clients find value in the complex challenges related to mergers and acquisitions, clinical integrations, regulatory compliance, business valuations, and fair market value assessments, and tax and assurance. For more information, visit pyapc.com.
Good afternoon. This is Tynan Kugler. I'm a principal with PYA, and I am here with Rebecca Schaefer of K&L Gates to talk about research-related developments to watch. We are number 10 in AHLA's top 10 issues in health law for 2023. And I am delighted to be here to talk through a lot of exciting developments with Rebecca. So before we get into it, I'm going to turn it over to you, Rebecca, and just have you introduce yourself as well.
Thanks, Tynan, and it's great to be here with you. And thanks to the listeners. Yes, it's fun to be bringing up the rear in the 10th part of the series. So yes, as mentioned, I'm Rebecca Schaefer, a partner in the healthcare and FDA practice group at K&L Gates, and I'm a healthcare and research, regulatory, and transactional lawyer. I'll also just mention before that I was formerly in-house at an academic medical center and had responsibility for, among other things, the clinical research program and supporting research administrative offices. So that gave me a bit of a front row seat to some of the operational issues that research institutions face and will face in implementing some of the changes we're going to talk about today.
Yes, and I'm glad that you mentioned for our listeners, and also grateful to AHLA for helping put this on. But why don't we just dive right in and talk about some of the items that you wrote about. The nice thing I think about your article was you hit on 5 or 6 sort of key topics, and one of the things that's been exciting about sort of where we've landed in this podcast series is there have even been some, I would say, some focus on some additional developments, refocus on some things that you had written about. So look forward to hearing about those. When I think about research and we talk about changes in research, we know that sort of year over year, there are hot topics that come up, and there are developments that come through a variety of different ways, whether it's policies, rules, statutes. And I'm curious to know when you sort of look big picture, what kind of policy initiatives sort of come to mind when you think about 2023 overall?
Sure. So yeah, and you're right that there have been some developments even since the article went to press at the end of 2022, and glad to highlight those here. And I think anything in this space deals with a little bit of alphabet soup. So one of those new updates would be Fedora, and we'll come to that in a moment. But the FDA omnibus legislation, but really starting first on the regulatory front, and this was covered in the article. You can give a little bit of a what to watch for add-on here, but the FDA's notice of proposed rulemaking that was put forward in September of 2022 is one example of some regulatory changes afoot, and FDA's intent to streamline and clarify, including as was required under the 21st Century Cures Act, certain requirements for clinical investigations and for cooperative research. As listeners are likely aware, there's 2 primary regulatory frameworks governing human subjects protections in research. There's the federal policy for the protection of human subjects, which is colloquially known as the Common Rule, and that obviously applies to federally funded human subjects research. And then the FDA rules under 21 CFR Parts 50 and 56, which apply to clinical investigations regulated by FDA. And the challenge is that if you've got federal funding for an FDA-regulated study, both sets of rules apply. So folks were eagerly awaiting the harmonization proposal from FDA, which does take a number of steps towards reconciling their requirements with those of the common rule. For example, adding elements to informed consent, and interestingly, specifically around, or at least what I took note of was informed consent requirements pertaining to subject samples, and the impact that's got potential to have on use of samples for whole genome sequencing, which is, an activity gaining interest and speed given the potential for genomic data to drive drug target discovery. So that's just, one aspect where there were informed consent and IRB requirement updates through the harmonization prong of this two-part notice of proposed rulemaking. What I'll call out, though, is there were a couple of things FDA declined to propose in the nature of harmonization. One was it was not proposing to lessen requirements for IRB review of in vitro diagnostic studies using leftover de-identified specimens, and that oversight is retained, at least in the FDA proposed rule, whereas the common rule considers those activities as non-human subjects research. And the other call out from that, and then I'll just briefly mention the cooperative research component of the proposed rule, is FDA did not propose to adopt broad consent. And that probably reflects the reality that many research institutions have not utilized broad consent flexibilities under the revised common rule. And that just relates to administrative difficulties created by needing to track subjects who decline and ensure they're never included in studies for which there's a waiver of informed consent. So that's on the harmonization side. And then on the single IRB review side, which was the companion notice of proposed rulemaking from FDA at the end of last year, would require a single IRB for all U.S. sites participating in FDA-regulated cooperative research. But it does have a number of exceptions for IND-exempt studies, non-significant risk device studies, and IDE-exempt device studies. So just to wrap up on this topic, a number of research institutions and other organizations, including the AAMC, have commented. And I think we can anticipate the final rules to have clarifications based on those public comments when they're released. Timing TBD.
That was gonna sort of be my next question is, everybody always wants to know, when is this going to occur? If you had a crystal ball, could you say, here's what we're thinking? A little bit of a loaded question, I know, for you. So would be interested to know if you think that's something we're going to see in 2023, or should we add this to top 24 issues?
Revisit this time next year.
Right.
Yeah, so I think, FDA missed the notice of proposed rulemaking deadline required under the Cures Act by about 3 years. And also just if the lengthy process to arrive at the revised common rule in 2017 is instructive, it may be some time before we see the FDA final rules on this. But what I'll be watching for, whenever they do come out, is whether they increase or decrease the daylight between the FDA, parts 50 and 54 and the common rule, because there are some competing considerations between issues that are discrete to FDA regulated clinical investigations and the desire for harmonization. But when they do come out, I think folks will experience a similar process as when the revised common rule came out. They'll, take a look at their human subject ethics program, standard operating procedures, their IRB reliance agreements, their informed consent templates, and consider any updates that are indicated.
Great, a lot to kind of look out for there. So kind of continuing down that FDA path, were there any other sort of changes to touch on as it relates to the omnibus appropriations bill? Anything there? I know that was one maybe that wasn't touched on as much in the article, but curious to kind of hear what's going on that front.
Sure, thanks. Yeah, so this was signed into law after the article went to press. It was December 29th, 2022 is when President Biden signed the Consolidated Appropriations Act, which included the Food and Drug Omnibus Reform Act, or FDORA. A few places I'll just highlight that are relevant to the research community. One is Section 3601 of FDORA that requires clinical trial sponsors to submit diversity action plans for certain late-stage drug trials, including all phase 3 trials, and as well as most device studies. But this is all in the vein of promoting clinical trial diversity. And those action plans need to state goals for enrollment, rationale, and really an explanation of how the sponsor intends to meet those goals. For what to watch for on that front, FDA is tasked under the law with updating guidance on diversity action plans for clinical studies, and also hosting public stakeholder workshops. So, if folks are interested, they could watch the scheduling of those and participate. The one other thing I'll call out from FDORA is the amendments to the accelerated approval framework under the Food, Drug, and Cosmetic Act. With these changes, FDA will be required to address, among other things, post-approval study requirements for sponsors, marketing products approved under an accelerated pathway, and the law gives FDA enforcement authority for a sponsor's failure to conduct those post-approval studies with due diligence or to timely submit reports. So the clinical trial diversity and the accelerated approval pathway are just two of number of changes impacting clinical research in the omnibus bill. Maybe one last call out is the law expanded FDA's, or really clarified FDA's authority to conduct biomonitoring research inspections, expressly permitting inspections of facilities involved in the preparation, conduct, or analysis of clinical and non-clinical studies that are submitted to the FDA, which is just a heads up that this, its scope could reach an increase or result in an increase in the number of FDA inspections of research sites.
Yeah, that's a lot of, so much of it is news that results. It's interesting about the acceleration with COVID, and I've always sort of harkened back to get your house in order from the standpoint of having everything in place if somebody shows up at your door, and making sure that you understand that you have everything as it needs to be. So one of the other things that I know you and I have talked about leading up to this is just all of the exciting things that are coming up around, in particular, the Cancer Moonshot Initiative, and some of the things that were further honed in and discussed in the recent State of the Union address. And, one of the things that was just fascinating to me in that part of in the transcript that came out after that was, the fact that the goal, there's some, pretty lofty goals, but you can also sort of see that there's been so much good progress in this space and the renewed focus, but that the goal to cut cancer death rates in half, or at least by half in 25 years, it is one of the items that was put forth. And perhaps this is another area you can touch on, is that there was also the mention of the fact that there are like 30 new federal programs, policies, resources, all kinds of things that are coming out around some of what was discussed in that State of the Union. So I'd be curious to know, from a research perspective and sort of from your purview, what you think we're going to see there that may be kind of hot off the press too from when the article was published.
Right. Yeah, I appreciate that. And yeah, I agree, really lofty and laudable goals, put forth in the February 7th State of the Union address, and, aim high.
Right.
So, this is a continuation of a policy initiative really begun under President Obama's administration when now President Biden was vice president. And, as noted, right, it's a mission to accelerate the fight against cancer. And so part of the announcement at the State of the Union was reigniting the initiative with renewed White House leadership. I think President Biden has described it as pulling together a cabinet specific to this focus. And one of the things that's a call out, and getting back to your question about where, funding can be anticipated, or how to watch for what this means in practice for specific programs that spin out as part of the initiative. The important thing to note was that the 2016 appropriation, or really funds made available in part for this initiative under the 21st Century Cures Act, were 1.8 billion. And there's an expiration date of this year on residual funds from that initial appropriation. And so in the State of the Union, President Biden urged Congress to reauthorize the National Cancer Act. And the White House has articulated support for another bipartisan effort to build, and this is in particular to you, where are we going to see some investment, cancer-focused clinical trial networks. And I think this is, in part consistent with some of the other clinical trial diversity initiatives, companion and other veins of the administration, but, desire for clinical trial networks that reach every community, ensuring that we've got representative populations. We're reaching folks in all areas of our community to holistically and in a represented way be striving for innovation in cancer therapies. So yeah, that would be my one call out for clinical trial networks is going to be, I think, even an area of increased investment.
Yeah, and it's funny that you now sort of putting sort of two and two together. I think one of the things that we've seen a lot of is on essentially the academic medical center side, where you've got really strong clinical research infrastructures, the number of affiliations that are occurring and attempts to build relationships out in the community is probably part and parcel related to some of what you've described. So be interesting to see how that continues. So you mentioned a cabinet being potentially created, and I think there are other agencies and other organizations that are also in development from a creation standpoint, one of which is ARPA-H. So give us a little insight on that.
Yeah, and we just, keep going with alphabet soup, right? So ARPA-H is the Advanced Research Projects Agency for Health. And this is a fledgling agency presently nestled under NIH, but its director reports directly to Secretary Becerra. Its goal is to drive transformational health research innovation and encourage cross-sector and large-scale study, primarily targeting potential cures for diseases such as cancer, again, Alzheimer's, diabetes. And really, it's meant to be a disruptor in some ways to traditional means of accomplishing research and really achieving translation of discovery into real-world use, clinical applications. So awardees for ARPA-H funds are meant to tackle new ways to achieve high-impact biomedical and health research. Again, that can't readily be accomplished through traditional research or commercial activity. The appropriation for through fiscal year 22, and the funds are available through September 24, is $1 billion. And just this month, I'll flag, one of a number of announcements coming out of ARPA-H. But on February 10th, the agency launched an effort to speed public-private partnerships designed to more rapidly transition biomedical discovery into the real world. And that's contemplated to happen through partnership intermediary agreements and that make transition resources, again, bringing discovery to market, essentially, available throughout the entire program lifecycle. In other words, you get parties planning for real world translation from the beginning. And so the agency's announcement suggested that these PIAs, partnership intermediary agreements, would be established with nonprofit partners who have a track record of commercial sector and transition expertise. And they would engage academia and industry on behalf of the agency to speed solutions to market. So just for what to watch for here, I think, there are bills currently under consideration additional funding under consideration that would further clarify and codify and support the role of this new agency.
I think we've got time for probably one more topic, and how about if we leave the alphabet? We sort of did the reverse alphabet there,
Yeah.
but let's leave the alphabet and go to numbers, and talk finally about Presidential Memo 33 and the developments that are around that, and some of what we think we can expect to see there.
Sure. Yeah. Happy to switch gears to the foreign influence space, and then we'll bring it home. So, as I think this audience would be familiar, the Presidential Memo 33 is focused on securing federally funded research and development from a national security perspective. And there was an implementation guidance that was released in January of last year that informed oversight expectations and requirements for research institutions to ensure, again, national security of government-funded R&D. The guidance, wrestles with a tough balance between and articulations in the presidential memo and all around this recognize a tough balance between maintaining an open research culture that's really premised on collaboration and transparency, data sharing, et cetera, with mitigating research integrity risks that are posed by those seeking to misappropriate R&D to the detriment of national economic security. So what this implementation guidance set forth, and jumping ahead, what to watch for is how the grant making agencies adopts their version of it through their own program requirements. It had 5 areas of focus, notably seeking to streamline or standardize disclosure requirements for disclosures that would assess conflicts of interest and conflicts of commitment. This would be trying to, make sure we know if investigators have foreign affiliations, other support for their NIH or other federally funded research that's, coming from internationally. And I'll mention here, just at the end of August last year, the National Science and Technology Council Subcommittee on Research Security, which I know is a mouthful, but that's the the council that's spearheading this, announced draft standardization data fields and instructions for these types of disclosures, and they invited public comment, which closed at the end of October. So I think that we can expect more development and progress on that front. I'll just briefly mention some of the other elements of the implementation guidance, and then what I think are sort of the takeaways or what to watch. But there's, treatment of a desire to universally adopt and harmonize the use of researcher digital persistent identifiers, and that's to aid in sharing and reporting it through digital research administrative systems. On this front, just as a practical matter, NIH already requires principal investigators to be registered with ORCID. And at the end of just this past month, January of 23, it looked like NSF was moving in that direction as well. I think most notably from the implementation guidance was the inclusion of a section on consequences for violation of disclosure requirements. And this really, inclusion of this section may signal a shift in enforcement priorities from, what is historically focused on individual investigators and whether they've underreported their foreign affiliations, their other support, and really to more of a focus on scrutinizing institutional controls. But while I say that, I know the factors cited is relevant to, assessing institutional liability for noncompliance. We're still, set a pretty high bar. For example, whether the organization failed to make its research community aware of disclosure requirements, period, or whether it knew if it knew of an individual's failure to disclose and didn't remedy that prior to the grant application or other, certification. So this, and also the implementation guidance's discussion of research security program expectations, are prompting institutions to take steps now to educate leadership on the priority of investing in compliance in this space. Some are considering conducting updated security assessments, and that could be holistic as part of for example, where these AMCs are embedded in healthcare providers, routine assessments you're doing for HIPAA purposes anyway.
Right.
And also preparing for training their research communities and particularly their investigators on the disclosure requirements. So those are, again, just some of the specifics, but really what to watch for, and institutions can tailor this based on the, predominance of their federally funded portfolio, whether it's NIH, NSF, DOD, you name it, figure out and be on the lookout for how these requirements are translated into those specific grant making agencies program guidance.
Yeah, and I think to me that's of all of the things that you've talked about, that's from an institution standpoint. One of the things that stuck out is that if this is heading down the pike, it's something that everybody needs to back to the sort of get your house in order. It's a good time to do a check and see if in fact you have all the things in place that you mentioned. So I think that hits on most everything that was in your article and that you and I had talked about. I don't think we have any other letters or numbers to cover. So but I do want to thank you, Rebecca. This has been great for me, as well as to just be able to learn a little bit more about what's happening 2023, and really do look forward to following some of this into 2024. So want to just turn it over to you for any final comments, and then we can close out and end the series.
Yeah, no, that sounds great. And thank you, Tina, for leading the discussion today. And it's really great to talk with you. So I think, my concluding remark would just be there's gives and gets in these developments, right? Gives in terms of new gives on the part of research institutions. That's the perspective I'm speaking from, in terms of revised or new regulatory obligations, right? Those are going to be burdens or just, compliance considerations to contend with, but gets in terms of new funding opportunities, whether that's through ARPA-H or, what comes of the Moonshot Initiative. Mm-hmm. And so, both burden and opportunity, and gives and gets, but we'll continue to watch. And so thanks again for the opportunity to talk with you today.